Hello, everybody. I am glad again to be with you today. My name is Wayne, and today we are focusing on terrorism and the law and our introduction to terrorism and threat assessment. We shall be talking about terrorism and the law and our introduction to terrorism and threat assessment. Now, some of you have already sent the assignment, and some of you have not. Take note, take note that the assignment is very important because it will form part of your continuous assessment. Just take note of that. And when we are talking about terrorism, we are talking about a very serious matter. And time factor is very important when we are talking about these issues. Time factor. We are talking about responding to terrorist attacks. We are talking about preventing terrorist attacks. We are talking about picking indicators of terrorist planning at the intelligence gathering stage. We are talking about being a first responder. And being a first responder for those who work in the military, for those who work in the police, and even for you who work in the private sector, being a first responder is about time. Time matters a lot. So send the assignment to maganiwayne@yahoo.com so that you are not starting to fall in the wrong side of the book with me. Terrorism and the law. What is terrorism and how does it concern the law? Under the lessons we have conducted since we started, we agreed that terrorism is still very difficult to define, and people define terrorism in different ways. And we say the confusion on the definition of terrorism abounds. It continues. It continues, and I don't think the experts and the researchers will finally settle on one definition. The term terrorism has no settled meaning. In fact, one scholar has counted 22 different definitions of terrorism in federal law alone. This is when we talk about the United States. 22 different definitions. The other time we saw there was a group of experts who were tasked with a definition of terrorism, and over 200 of them, and they couldn't actually agree on the definition of terrorism. So what is terrorism and the law? Terrorism is defined variously by the perpetrator's motives, methods, targets, and victims. Motive-based definitions suffer from confusion because they attempt to carve out an exception for assertedly legitimate armed struggle in pursuit of self-determination. For example, under one of the various United Nations resolutions addressing terrorism, armed and violent acts do not constitute terrorism if committed by people seeking self-determination in opposition to a violently enforced occupation. So still under the United Nations, there is still an issue that where it is stated that armed and violent acts do not constitute terrorism, only if it is committed by people seeking self-determination in opposition to a violently enforced occupation. We are going to discuss this topic today with reference to Prevention of Terrorism Act of Kenya, Act number 30 of Kenya. We are going to discuss it in relation to the laws of Kenya. And I want you to read this document, which I have already sent to you, Prevention of Terrorism Act. I have already sent, through the notes I sent this act. Read it, because this is going to be our reference. It's going to be our reference moving forward as we discuss this topic. An act of parliament to provide measures for the detection and prevention of terrorist activities, to amend extradition, Commonwealth countries Act, and the Extradition, Contiguous and Foreign Countries Act, and for connected purposes. So this is an act of parliament. That is only what you need to know. It is an act of parliament that really addresses the topic of terrorism, because you know Kenya, we are one of the countries that we are in the middle of this war of terrorism. And I can tell you, it is never going to end for us. It will never end for us, my friend. So we better each and every day remember that terrorism is a threat that we have to accept it is going to live with us. So we are going to base our discussion on this act. According to the Prevention of Terrorism Act number 30 of 2012, a terrorist act means an act or threat of action which involves the use of violence against a person, 2, endangers the life of a person other than the person committing the action, 3, creates a serious risk to the health or safety of the public or a section of the public, 4, results in serious damage to property, 5, involves the use of firearms or explosives, and then 6, involves the release of any dangerous, hazardous, or toxic material, radioactive substance, or microbial or other biological agents, or non-toxin or toxin into the environment. This is self-explanatory. It is also in the Act. You can read deeper about it. Terrorism also is an act that interferes with an electronic system, resulting in the disruption of the provision of communication, financial, transport, or other essential services. Interferes or disrupts the provision of essential or emergency services. Prejudices national security or public safety, and which is carried out with the aim of intimidating or causing fear amongst members of the public or a section of the public. Remember fear as one of the characteristics of terrorism from the previous lessons. It is also intimidating or compelling the government or international organization to do or refrain from any act. Remember the terrorist triangle. A attacks B to coerce C to change or to meet their demands. It is also destabilizing. It causes destabilizing the religious, political, constitutional, economic, or social institutions of a country or an international organization. Part 3 of the Prevention of Terrorism Act of Kenya talks about offenses. That if you commit this kind of an offense, it is actually in the category of terrorism. So, commission of a terrorist act, offenses. A person who carries out a terrorist act commits an offense and is liable on conviction to imprisonment for a term not exceeding 30 years. Where a person carries out a terrorist act which results in the death of another person, such a person is liable or conviction to imprisonment for life. If the act causes death to another person, then you are likely going to face a life sentence. Read the following offenses in the act. Read the following offenses in the act. Collection or provision of property and services for commission of a terrorist act. Possession of property for commission of terrorist acts. Possession. Arrangements for the retention or control of terrorist property. Dealing in property owned or controlled by terrorist groups. Soliciting and giving of support to terrorist groups or for the commission of terrorist acts. You know the term soliciting. Soliciting is to beg or to beg or to request something. And then a facilitation of terrorist acts. Harboring of persons committing terrorist acts. Provision of weapons to terrorist groups. Read this from the Terrorism Prevention Act number 30, 2012, Laws of Kenya. Also read direction in the commission of a terrorist act, possession of weapons for terrorist purposes, and then 12b, possession of weapons in places of worship, institution, or public places. Now, I want you to take note of this one. Failure to prevent entry of weapons. So if you are a security officer, you are a security manager, you are a security guard, and you fail to prevent entry of weapons. Now, this is very tricky. It is very tricky because you look at Kenya, there are people all over the world, there are people who are licensed to carry firearms. And then it says here that if you fail to prevent entry of weapons into a particular premises, you may be liable, you may be held liable for an offense. In this sense, any person who, being in charge of any premises, institution, or public place within which illegal weapons are recovered shall be deemed to be in possession of such weapons and shall be liable to imprisonment for a term not exceeding 30 years. You see, any person who, being in charge of any premises, institution, or public place within which illegal weapons are recovered shall be deemed to be in possession of such weapons. It will be concluded that you are the owner of the weapons. If weapons are found in your premises and you are the one who is in charge of security there, and you did not report that weapons are here, then you shall be deemed to be in possession of such weapons, and you shall be liable to imprisonment for a term not exceeding 30 years. That is why we insist that you have to carry out proper security patrols. Patrol is walking from one place to the other, examining areas where illegal items or weapons can be hidden, or checking out for issues that may lead to unsafe situations or may lead to breach of security. Patrolling is actually checking these areas as you patrol. So when you patrol, you have to make sure that you check for weapons. You check areas where weapons can be hidden. And at your premises, you think about your premises. You know areas where items can be hidden. So patrol, check those areas. Excuse me. It shall be a defense if the person referred to in Section 1 shows that he had no control over the entry of the weapons in any premises, institution, or public place. That is just a defense. But once they are found there, before you can offer your defenses, you will have suffered a lot. So just ensure that you do not allow weapons into premises, and also you patrol thoroughly. If there is anybody who you notice is carrying a weapon, a pistol, or a gun, then this person, you have to ask them to produce their firearm handling license, which is usually issued by the Kenya Police. Those who are in class now, who work with Kenya Police, can explain to you that it is a tedious exercise before you can be licensed to carry a firearm. It is an exercise that is very, very, very challenging. Now, also from the Act, we are also going to read about radicalization. And what is a radicalization? A person who adopts or promotes an extreme belief system for the purpose of facilitating ideologically based violence to advance political, religious, or social change, commits an offense and is liable on conviction to imprisonment for a term not exceeding 30 years. I also want you to read Part 3 offenses from page 13 to page 30F of the Terrorism Prevention Act, Kenya, Act number 30 of 2012. Read pages 9 to page 17 of the Act. And then also we are going to cover Part 4, which talks about investigation of offenses, and Part 5, which is trial of offenses. This one we are going to cover them under Lesson 11. We are going to cover investigation of offenses and part of the trial of these offenses in Section 11. Now, let's go back to law. Ordinary criminal laws applied to terrorists. In many instances, the difficulties of defining terrorism may not matter. Prosecutors often do not need to worry about the definition of terrorism or rely on special anti-terrorism legislation when charging suspected terrorists. On the contrary, most acts of terrorism violate ordinary criminal laws. We say most acts of terrorism violate ordinary criminal law. To intimidate a person, to threaten a person, to use a weapon against a person, to shoot a person, to carry explosives in the bag with the intention of committing a terrorist act, those acts violate ordinary criminal laws of general application. For example, murder is murder. whether it is committed by a terrorist or whether it is committed by a mobster or an armed robber. Murder is a murder. So if a terrorist commits murder, then that violates ordinary criminal laws. The same is true for assault, kidnapping, arson, and many other offenses that terrorists might commit. These acts violate ordinary criminal law. Kidnapping is against ordinary criminal law. So whether committed by a terrorist or whether committed by another different person who is not a terrorist, it is still against the law. As a security officer, as a security professional, up to this stage, you should be able again to understand what are the types of offenses that are against international law and also against our penal code, Kenyan penal code. What are these types of offenses? For example, assault, for example, kidnapping, for example, rape, for example, arson. What is arson? Arson is deliberately putting a structure on fire deliberately. For example, let me talk about a man and his wife. You marry a wife and then you later divorce her, and then she comes in the middle of the night when you are not there, and then she burns the house. That is arson, deliberately, out of revenge or out of anger. You know it happens, eh? So be very careful when you are doing these things, man. That is arson. So these acts, whether committed by terrorists or whether committed by anybody else, they violate ordinary criminal law. Now, this is where terrorism touches the law, that the acts that terrorists commit violate ordinary criminal law. Yet, a decision to charge and then try a suspected terrorist as though he or she were just another criminal suspect raises important questions. Is it relevant whether a person is a terrorist? Is equality of treatment of suspected terrorists and other suspected criminals necessary to preserve the fairness of the trial for the accused? Or does treating terrorism the same as other forms of crime overlook important distinctions, some of which might benefit suspected terrorists? These are some of the questions that you might ask. I know I think you are during this course, a diploma in security management. You are also going to be taught by our fellow trainers on criminal law, and when they teach you criminal law, then you will understand some of the basics of the things that we're talking here about trial of the accused person, fairness. These things you are going to learn them also under criminal law. We also say, with reference to the United States, legally, terrorism is defined in the U.S. Code as premeditated, politically motivated violence perpetrated against non-combatant targets by subnational groups or clandestine agents. The U.S. Department of Defense defines it somewhat more broadly, calling it, you see also in the U.S. there is a definition of terrorism under FBI is different from definition of terrorism under the U.S. Code, is different from definition of terrorism under the U.S. Department of Defense. It is completely a broad matter. The U.S. Department of Defense defines it somewhat more broadly, calling it the calculated use of unlawful violence or the threat of unlawful violence to inculcate fear intended to coerce or intimidate governments or societies in the pursuit of goals that are generally political, religious, or ideological. So that is another definition from the U.S. Department of Defense. Does the U.S. consider terrorism as a crime or an act of war? Historically, the United States treats terrorism committed by persons not acting for a nation state, i.e. non-state actors, as crimes to be addressed by domestic law enforcement authorities. The U.S. is a party to a number of international treaties that speak to forms of terrorism, but most of these conventions touch the acts as crimes and task the parties to establish criminal jurisdiction over offenders. The US is a party to a number of international treaties that speak to forms of terrorism, but most of these conventions discuss the acts as crimes and task the parties to establish criminal jurisdiction of offenders. Terrorism committed by a non-state state-sponsored terrorism is ordinarily considered a national security issue to be addressed by armed forces. Then we ask what legal theory is the US relying upon to justify the use of force against terrorists? Self-defense, in its joint resolution authorizing the use of force, Congress noted that the attacks of September 11 render it both necessary and appropriate that the United States exercise its right to self-defense and to protect United States citizens both at home and abroad in order to deter and prevent acts of international terrorism against the United States. And this one is an issue where we are questioning ourselves on what legal theory does the US justify using force against terrorists. For example, you will watch the movie Killing Osama bin Laden. On what legal theory is the US did the US use to use force and to eventually kill this person? The theory is self-defense, that this person intends to kill our people, to kill our citizens, so we have a right to self-defense, and during self-defense you can actually kill another person. Terrorism and international law. Terrorism concerns the law in several ways. Terrorism concerns the law in several ways. Terrorism concerns the law in several ways. Number one, first, the law obviously prohibits terrorist acts of various kinds like murder, hijacking, and destruction of property. Now we are talking, this is where you need to put a lot of concentration and you need to read this a lot. How terrorism touches the law under international law. First, the law obviously prohibits terrorist acts of various kinds like murder, hijacking, and destruction of property. Two, and sometimes more controversially, the law limits and regulates government responses to terrorism. The law, for example, specifies requirements of fair trials. It constrains methods of investigation, and it may prohibit certain forms of military action against suspected terrorists. And then three, the law may impose civil liability on terrorists and those who support terrorists and those who fail to provide protection against terrorists. And then also, four, terrorism is a scourge to which the international community has been striving to respond for decades. The obvious challenges it poses are not only long-lasting but also immediate. Wherever we turn these days across the world, we are confronted with increased risk of terrorist acts. Terrorism is a global phenomenon, sometimes closely linked to armed conflict, and one which the international community is increasingly facing. Terrorism negates the fundamental principles of humanity as the essential principles and objectives of international humanitarian law. What we mean to say is that the acts committed by terrorists are obviously against international law. Acts of murdering other people, acts of shooting other people, acts of using violence against other people, acts of threatening other people in order to achieve their ideological objectives, these acts are against international law. So, in short, we say terrorism is against the law. Terrorist acts are against the law and should not be allowed, and they should be condemned at all costs. In terms of international law also, we say, what does an act of war really mean? In the modern era, the phrase act of war is more a political term than a legal one. Historically, act of war usually referenced the rationale for nations to engage in international armed conflict. It could be a variety of things, to include unfriendly economic and commercial actions, or even simply insults to national pride, acts of war. Laws aimed specifically at terrorism. There are laws aimed specifically at fighting terrorism. Although ordinary criminal laws of general application already prohibit many of the kinds of acts that terrorists commit, Congress has enacted significant criminal legislation specifically aimed at terrorism. The U.S. Criminal Code, in fact, now contains an entire chapter addressing the subject. Uh, uh, How does the laws aimed specifically at terrorism differ from ordinary criminal laws? You see, again, they say those aimed specifically at terrorism differ a little bit from ordinary criminal law. The short answer is that they do not differ very much. Most of the legislation concerning terrorism does not actually apply just to terrorists. Instead, the legislation applies to everyone who commits the specific acts that it prohibits. For example, the offense of terrorist acts abroad against United States nationals can be committed by anyone who kills, kidnaps, or assaults a person within the United States as part of the conduct of transcending national boundaries, provided certain jurisdictional requirements are met. The prosecution does not have to prove a terrorist motive or an affiliation with a terrorist organization. Instead, it only has to prove that the defendant committed one of the offenses that the law prohibits. It just so happens that international terrorists are most likely to commit these kinds of offenses. Very few laws require the government to prove that anyone is a terrorist or has a connection to a terrorist group. As long as you commit an act that relates to breaks the international law or breaks the ordinary law, as we say, you murder somebody and you are prosecuted in court, the government doesn't have to prove that you are a terrorist. It doesn't have to prove that you are a terrorist. You have simply committed an act that is contrary to the law and you face the consequences. Research on what the law says about providing material support to designated terrorist organizations. I want you to research on that. What does the law say about providing material support? Because there are politicians, there are people, there are religious leaders who also support terrorism. They provide material support to designated terrorist organizations. Even countries, they provide material support to terrorism. There are countries who have been mentioned all over the world, like Iran, like the country of Somalia, that they provide material support to designated terrorist organizations, like Saudi Arabia. So you read about this, like Iraq, read about this, and then we can research more. Now, example of U.S. sentence. A maximum penalty of 15 years imprisonment for any person who knowingly provides material support or resources to a foreign terrorist organization or attempts to conspire to do so. If you support terrorism or you offer material and you are in the US, then you are likely to face a maximum penalty of 15 years. The term material support is defined as currency or other financial securities, financial services, lodging, training, safe houses, false documentation or identification, communications equipment, facilities, weapons, lethal substances, explosives, personnel, transportation, and other physical assets, except medicine or religious material. So that is what we call material support. Material support involves all those things that I have mentioned. Then let's talk a little bit about the UN Charter. The UN Charter provides two principal exemptions to prohibition on the use of force in international affairs. The UN Security Council, not the General Assembly, can authorize member nations to take such action by air, sea, or land forces as may be necessary to maintain or restore international peace and security. And also, the UN force can be used, the UN says force can be used in self-defense under Article 51 of the Charter. Specifically, Article 51 says that nothing in the present charter shall impair the inherent right of individual or collective self-defense if an armed attack occurs against a member of the United Nations, until the Security Council has taken measures necessary to maintain international peace and security. The UN, under UN law, it is allowed to use force against terrorists. It is allowed to use force against terrorists. It is allowed to strike them. it is allowed to kill them, to prevent them from committing terrorist acts which endangers or threatens the life of innocent people. So under the international law, under the United Nations, it is authorized, it is allowed to use force against terrorists. Legislation, law enforcement, and border security. Specifically, Kenya government continued to use the Prevention of Terrorism Act, amended in 2014, to investigate and prosecute terrorism. Crowded court dockets and the lack of continuous trials slowed progress on many terrorism trials. However, 2020 saw some closure on the criminal proceedings in connection with the Westgate Mall attack of 2013. A court found two men involved in this attack, Muhammad Ahmed Abdi and Hussein Hassan Mustafa, guilty of conspiracy to commit terrorism. The court sentenced them to prison for 33 years and 18 years respectively. A third man, Liban Abdullah Omar, was acquitted. I have spoken briefly about terrorism and the law. However, what I have said, I want you to read the Terrorism Prevention Act number 30 of 2012 under the Kenyan laws, and then you'll also expose yourself more to what it means. However, in conclusion, we say that terrorism under the Kenyan law, terrorist acts are criminal acts. Terrorist acts are not allowed. Terrorist acts are offenses that, if committed, then one is liable to be prosecuted in court of law. And if found guilty, then the act says the maximum number of years that you can be imprisoned for these acts. So what we need to say is that terrorism is against the law, both under the Kenyan law, under the international law, under the US law, under the UN United Nations law. Terrorism acts are against the law, and they should be condemned, and those people who engage in terrorist acts should be found, and force can be used against them, and they can also be arrested and prosecuted in court of law. So thank you very much. We are now going to move to another lesson. I hope that we can cover 2 lessons today, because there are some additional lessons that I want to share with you to prepare you for the future as a security manager, as a security supervisor, as a security officer. There are some very important presentations that I have from my own knowledge from the CSMP course at ISMI, and also from Leicester University, that I really want to share with you to prepare you for the future. So for today, thank you very much. I am going to proceed with the next lesson. So